Hey guys, Dark Angel here. So, as promised, I told you that I was going to do a reading of a case called City of Chicago versus Banker, 112 Illinois Appellate Court, 94 1904. Right here, just so you can see that. Yeah. This case is in reference to what the government don't want you to know. And then I have another one that I'm going to show you. I don't know if you can see that, but there you go. That right there, what I just showed you, is called the Sessions Laws. I'll get into that in another video, but right now I'm going to get into this City of Chicago versus Banker. And like I said, this case, the opinion was handed down by Mr. Justice Ball. Uh, this there's actually 10 Scottish cases that cite this case. Okay, in the event that you know. So, but a little history on this case though. This case is from 1904. Okay, if it did not have any significance, the FBI wouldn't have went around, or the feds, uh, to every library in the country and pulled it down off the shelves. Okay, I obtained this case from Harvard Law Library about 4 years ago. I went a couple weeks ago to get this case again because I wanted to. I don't even remember what the purpose was, or why I went to go back over there again to get the case, but I went to do something with it. And the young lady that was working the desk told me, she says, "Oh, that case, or that book that the case was in, had been pulled off the shelf." So there's that. I have a law library that is actually right down the street from my house, literally like 3 blocks away. And that's pretty much where I'm at all the time, in that law library. And that book pulled off the shelf. So I decided, well, you know what? I'll go online and look it up online and see if I can't get it online. And I went online, and I'll be damned, you can't find the case online either. So I was kind of confused with that, but I realized then, after having studied the case, read the case, then I realized why it was pulled off the shelf, and I'm gonna get into all that and show you all that. Okay. So for some reason, there's some kind of delay in the video. I'm not sure what that is, what it's about, or why it's doing that, but I'll look into it later. But if y'all can hear me, awesome. If not, then I'll reshoot this video at another date. So the head notes read in this case: unverified amendment token. Sufficient though interposed to sworn bill, the fact that an amendment to a sworn bill is unverified is waived and becomes immaterial where the defendant demurs thereto. Okay. Injunction with lies to restrain enforcement of municipal ordinance. A bill seeking an injunction to restrain the enforcement of a municipal ordinance states a case within the jurisdiction of equity, where it avers that such ordinance is unconstitutional and void, that the complaint is liable to arrest, prosecution thereunder, that he has no adequate remedy. No adequate remedy at law. that if such ordinance is enforced, his business will be ruined, and that there are many others similarly situated. Municipality powers of the charter of a municipality is the measure of its powers, and the enumeration of certain powers implies the exclusion of all others. Now, if you guys remember, a while back I did a video on that. Basically, what that is that's the uniform rule that is used in statutes, meaning that if a statute reads one way but it doesn't say another way, that other way doesn't matter. It excludes it. So, in other words, what I'm saying is this: the rule that is used, and it's still used today. This rule is a uniform rule. It's still used to this day. You can look it up, and you'll see that there's a ample number of cases that mention the Latin maxim. Okay, the legal Latin maxim. Basically, what it is I'll get into that. I'm not going to explain it right now. I'll get into it. Okay, so anyway, the powers of the charter of municipality is to measure its powers, and the enumeration of certain powers implies the exclusion of all others. Ordinance when restricting use of streets invalid. An ordinance which requires the owners of automobiles who use their vehicles for private business and pleasure only to submit to examinations and take out licenses imposes a burden upon one class of citizens in the use of the streets which is not imposed upon others, and such an ordinance is therefore void. Automobiles power a municipality to regulate use of. A municipality has the power to regulate the speed of automobiles and to require the use of reasonable safety appliances. See the reporter's note at the conclusion of the opinion. Proceeding to enjoin municipality from enforcing automobile license ordinance, appeal from the Circuit Court of Cook County. The Honorable Judge L. Healy, judge presiding, heard in this court at the March term of 1903. Disposition affirmed. Rehearing denied February 25th, 1904. And it's got the list of the attorneys that were all involved. So, the court was appealed to the Supreme Court, and the opinion, Mr. Justice Ball delivered the opinion of the court. On May 7, 1903, appellant filed a sworn bill against appellant and others in his own behalf and in behalf of others, similarly situated, in which he recites the automobile ordinance enacted by appellant on June 30, 1902. He says that he is the owner and operator of an automobile and is experienced in its management and uses it for his pleasure and in his business as a dealer in such vehicles, that he is not a common carrier, nor does he use his automobile for hire. That appellant, through its agents, threatens to arrest him for running his automobile without having first obtained a license in compliance with the ordinance, that he believes such ordinance is unconstitutional and void, in that it is double taxation of personal property, and prays for the injunction against the defendants, restraining each of them from arresting or prosecuting appellant or any other person similarly situated, etc. May 9, 1903. An unsigned and unverified amendment to the bill was filed, alleging that there are in the city of Chicago 1,500 other owners, users, and drivers of automobiles who are affected by such ordinance. On the same day, an injunction as prayed for was issued. This appeal was perfected from the interlocutory order. In the opinion, therefore, filed herein, we held that the original bill was not sufficient to entitle appealee to an injunction, and that the amendment thereto, although filed by leave of the court, being unverified, did not remedy the defects, nor supply the omissions of the sworn bill. Upon the petition for a rehearing, our attention is called to the fact that 10 days after such an amendment was filed, appellant demurred to the bill as it then stood. Thereby, the well-pleaded facts of the bill was amended were admitted to be true, and hence the fact that the amendment was not upon oath became immaterial. Fowler versus Fowler, 204 at 82. The bill as amended alleges, and the demurrer admits, that there are 1,500 other owners operators of automobiles who are situated as is appealee, each of whom is liable to like arrest and prosecution under the ordinance, that many suits will be brought thereunder by the city, that there is no adequate remedy at law, and that if the ordinance is enforced, the business of appealee will be ruined. Now, what I'm going to do is, because this case is kind of lengthy, the cases that it cites, these are all cases that are in relation to what this case is about. So it mentions Chicago versus Collins. It goes on to mention the city of Chicago versus Collins again, and in that, what they wrote, what Justice Ball wrote in his opinion was this. He said that they asserted that the city had no power to require a license for the use of private automobiles upon the city. They asserted that the city had no power to require a license for the use of private vehicles upon the streets, nor to impose a tax thereon by way of license. The court held that the right to travel being in the general public everywhere, all persons have a right to pass along and use the streets and alleys of a city in all their parts. And for all my privates out there, you heard what that said? Private automobiles? Yeah. Wait till I get to the good part. Full length and width thereof, that any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion or even an extraordinary method. That's your commercial aspect, the extraordinary. If it is not of itself calculated to prevent a reasonably safe use of the streets by others, that the power given to the city to regulate the use of the streets is conferred for, at 97, the purpose of keeping them in condition for public use and travel, that any usual method of travel along the streets cannot be declared a nuisance, that the regulation as to speed of travel is for the safety of the public, and that the regulations as to the certain occupations, there you go, if you remember that, occupations, you remember what that means, right? Commercial activity, jobs, commercial, see, occupations such as a hackman and others having vehicles for hire, or hire, are occupation license only and are an exercise of the police power. That a license implies a privilege, something that cannot be enjoyed without legal authority and cannot be demanded for the exercise of a right, free and open to all, as is the right of the citizen to ride and drive over the streets of the city without charge and without toll, provided he does so in a reasonable manner. Now, I want you to keep in mind what I just said right there about the free and open to all. Okay, that's going to come into play in the Sessions laws. And as you can see, that came straight from the Washington.gov website. This is the Sessions laws of all the states. And this is actually where you're going to find what you're looking for. This case right here, okay, just validates what this says. So, anyway, moving forward. Now, okay, something that cannot be enjoyed without legal authority and cannot be demanded for the exercise of a right, free and open to all, and is the right of a citizen to ride and drive over the streets of the city without charge and without toll, provided he does so in a reasonable manner, and that the authority upon the part of the city to impose a tax or to exact a license must clearly appear and must be strictly construed. Accordingly, the Supreme Court affirmed the decree of the trial court, which perpetually enjoined the enforcement of this ordinance. So, then they go on to cite a case, Wilkie versus the City of Chicago, the City of Cairo versus Brass. The reason why I'm skipping through it is because this case is pretty lengthy. So, Thomas versus W.L. Railroad Company, Keel versus City of Chicago, Bessett versus the People, and this is where I'm going to get in to, after he cited, so he goes, this is what he says. In Bessett versus the People, 193, the Supreme Court held that the laws which interfere with the personal liberty of a citizen and with his right to pursue such avocation or calling as he may choose cannot be constitutionally enacted unless the public health, the public health, comfort, safety, or welfare demands their enactment, and that it is the duty of the courts to determine whether or not a law impairing the right of a citizen to follow his individual preference in the choice of an occupation comes within any of these exceptions. Then follows a review of the facts from which the court finds the Act of 1897 to be invalid, and the judgment of the trial court is therefore reversed. Now that was in that Bessett case. So here's what it says now. In the case at bar, the right of appealee to use the streets is undoubted. It is true that he must use them without interfering with the safety of others in the exercise of the same right. Subject to that limitation, his right cannot be regulated by an ordinance. The fact that an automobile is a comparatively new vehicle is besides the question, meaning it don't matter that it's a car. Period. It don't matter. The fact that an automobile is comparatively new is a new vehicle is besides the question. The use of the streets must be extended to meet the modern means of locomotion. Moses versus PFW&C Railroad Company 21. Okay, so you guys heard that, right? There you go. Now, hang on, it's not over with yet. The speed of the automobile may be regulated, and reasonable safety appliances such as gongs, brakes may be required. But to compel one who uses his automobile for his private business and pleasure only to submit to an examination and to take out a license, if the examining board see fit to grant it, is imposing a burden upon one class of citizens in the use of the streets not imposed upon the others. We must therefore hold this ordinance so far as it obliges appealee to take out a license before he can use his own automobile in his own business or for his own private pleasure is beyond the power of the city, and is therefore void. The reporter's notes. The legislature of 1903 enacted a law entitled An Act to Regulate the Speed of Automobiles, which is your Motor Vehicle Act of 1903, and other horseless conveyances upon the public streets, roads, highways of the state of Illinois, which seems to have been much overlooked. The full text of this law is to be found in our second supplement to Starr and Curtis, Anointed Illinois Statutes, page 500, and on page 300 of the Session Laws of 1903. This law is, however, in no wise applicable to this case, but we refer to it as a matter of general interest. The decree of the circuit court is affirmed. So the case was affirmed, meaning that, you know, the fees that he complained about, the license and the registration and all that, no, you never needed it. And it's interesting because this case speaks on the session laws that I'm telling you about. The sessions laws is what makes the statutes. Okay, there it is right there. There it is right there. I don't know if you can see that, but public vehicular travel as a right. So, like I said, that's going to be in a different video. So here is my analysis of the case. Okay, this is my emphasis of facts. So you ask, how is driving a right? Simple, the 10th Amendment. Once the Supreme Court ruled that driving was in fact a right, it became a unenumerated right. Rights not founded in the Constitution are protected and guaranteed by the 10th Amendment or that document. Also, under the legal Latin maximum, expressio unus est exclusio ulterioris, it is the uniform rule that the expressed mention of one thing in a statute implies the exclusion of all others. State Ex Rel. Port of Seattle versus Department of Public Services, Washington 2D 102 95 2D 1007 1939. Personal private automobiles is not included in a statute. That's what that law means. And that's what I've been trying to tell all y'all over the course of the years and the months, that if a statute doesn't include something, it excludes everything else. All the statutes say motor vehicle. Automobile and motor vehicle have two distinct different definitions. Okay, one connotes as a pleasure vehicle, one connotes as a commercial vehicle. Now, granted, you're going to sit there and say, well, the states have. Yeah, I know what the states have. But the states also have a problem with their word, because of the simple fact is what? The Supremacy Clause in the United States Constitution says that if a state comes in conflict with federal law in its rulemaking, statutes, regulations, rules, policies, definitions, etc., etc., the Supremacy Clause gives the federal law jurisdiction. The federal law supersedes the state law. The federal law takes precedence over state law if it comes in conflict. Well, plain and simple English people, the statutes of the state for needing a license to drive on the roadways comes in conflict with the federal law, and comes in conflict with, the sessions laws. Because here's the thing. So I'm going to touch on a little bit of the sessions law for you and show you a thing or two. So in the sessions laws, hang on. In the sessions laws, this is exactly what it says in the sessions laws. In the sessions laws, depending on what state you live in. Now, basically what you'd have to do here is, I guess I can just go ahead and touch in on this in this video. Okay, so this, what I'm reading from, is a criminal complaint that was filed and served on Congress and the Department of Justice on March the 9th, 2006, and remains wholly without rebuttal or any sort. They never even answered this. They never rebutted it. They never rejected it, etc., etc. So this is what the sessions laws say. Now, in the state of Washington, I tracked this law all the way back to the very beginning of 1915. Okay, from today. Well, not today per se, but this past month. And there's a phrase in the law that's still there to this day. So basically, what it says is this: this is where you're going to find this law. You have to look up the definition of public highway, okay? Because that's where a lot of people get confused. Public highway is for the public. And this is what the Sessions Law in Washington says. Public highway at 46, Administrative Code 296 32 210. Definitions: public highway. Every way, land, road, street, boulevard, and every way or place in the state open as matter of right to public vehicular travel, both inside and outside the limit of cities and towns. Whoopsie. So now you see how it's always been a right. And even in the Sessions Law, it even tells you about the commercial. There's the AGO, Attorney General, in that aspect. It was in 19. This was just recent too, so just know that for all you guys that don't know that. I'm gonna actually read you part of what the AGO says in this. Okay, so the AGO is actually confirming and letting you know. So what I'm getting at is this. So the AGO said that the use of the street of the highways is not a mere privilege. Okay, so this is just, I'm just reading a little part of what it says. Okay, and so I'm not going to get into all of it. As to the power of the legislator to prohibit a condition, special, or extraordinary uses of the highway, commercial use as it sees fit, Stevenson versus Benford, Robertson versus Department of Public Works, and let's see, what is that one? Pacific Island Taft Bureau versus Schaffel. And now these are the cases. These are all cases that the AGO is citing, telling you what the duties of the legislation is. Under the power to regulate private use of our highways, our legislator has required that motor vehicle operators be licensed. RCW 4620. Undoubtedly, the primary purpose of this requirement is to ensure, insofar as possible, that all motor vehicle operators will be competent and qualified, thereby reducing the potential hazards or risks of harm to which other users of the highway might otherwise be subject. Did you hear that, what I just said? What did I just say? Did you catch the catch in there? Other users. That's the catch. So if certain automobiles are to be licensed, registered, tests done, etc., and to protect other users of the highway, who's the other users? Private personal automobiles. Common sense. That's what that means. Those Sessions laws validates that case that I just got through reading. It lets you know. This will be a different video. This is a totally different video because I'm going to read just about all this to you in this one. I didn't read all of the banker case, but I read the most important part of the opinion. That the case was affirmed, and that what the opinion said. And that's the most important part. Like I said, that case has been pulled from every library across the country. That's because they don't want you to know that a license actually is a burden on a class of people. And there's 10 cases supporting that fact. So there's that. Well, anyway, I didn't want this video to get too long because I am under the weather, and as you can hear in my voice, I'm all a little stuffy and stuff like that. So, with that being said, I am going to close this video out. Hope you all have a good one. Travel safe, my friends. And this is Dark Angel. I'm out of here. Deuces.